Good morning. It's a great day here at Elville and Associates, and welcome to our Elville webinar series. I'm Jeff Stauffer, Community Relations Director with the firm, and I'll be your moderator today. I'm pleased to share with you our topic today, a recurring presentation that we offer, which is the financial planning aspects of estate planning, presented by Elville and Associates Senior Associate Attorney Shannon Werbeck. And you're in the right place for high-level legal education today. We encourage your general questions. So please, as always, note them in the questions panel on your screen. And as always, we'll take time throughout the presentation to address them. Please offer your questions. They always help the presentation and add value. They help others learn. So pose your questions at any time. And yesterday by email, you received the presentation slides that Shannon will be referencing. If you didn't receive this for some reason, it is also in the section marked handouts on your screen to download at this time. And we also have some professionals on today's webinar. Welcome to you as well. 1.5 continuing education hours are available for most everyone in attendance. So if I don't have your ID number yet or an accreditation that you'd like me to provide for your CE hours, please send that over to me today, as I'd like to get those sent out for you as soon as possible. Everyone will also receive a post-webinar feedback email right after the presentation. So please ask that you fill that out for us at your earliest convenience, and we always read and value every comment that you have to share with us. And here at Elville & Associates, we are always here as a resource for your family and you. If you're just getting started with your planning, if you have old, outdated documents to address, which is not out of the norm or unusual, or perhaps another matter, Shannon and the rest of our team here are here to advise you and counsel you every step of the way. So I'd like to tell you just a bit about our firm and a bit about Shannon, and we're going to jump right in. So you should be able to see my screen here. Elville & Associates. Well, I jumped the gun there a little bit. I want to talk so much about Shannon. I forgot to tell you a little bit about our firm here. Elville & Associates, founded in 2010 here in Columbia by our leader, managing principal, and lead attorney, Stephen Elville. We offer several different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville & Associates. We do that in many different ways. 3 of them are through our planning processes with our clients. And we have many different programs to suit needs for all individuals and families here at the firm. We also offer many different educational webinars and workshops in the communities that we serve each year. We do lots of webinars. We also love to do in-person presentations. Shannon and I were just at the Quince Orchard branch of the Montgomery County Public Library System a week or 2 ago for a wonderful presentation with many of their patrons and members of the community. It was a lot of fun. We loved getting out into the communities that we serve. Also, we have an accredited client care program here, one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Shannon. Shannon's work as an attorney for the past several years has been centered in estate planning, along with assisting clients with special needs planning and elder law matters. Shannon is a graduate of the University of Baltimore School of Law and was admitted to the Maryland Bar in 2020 as a member of the Maryland State Bar Association. Shannon is our estate planning team leader here at the firm, and she educates and counsels clients through the entire estate planning process, beginning with the initial consultation, followed by the design and implementation of their plans, as well as the necessary maintenance and updating of their planning as changes occur in their lives and laws over time. And Shannon was nominated by her peers and named to the Rising Stars list of Maryland Super Lawyers for the first time in 2023, and again in 2024. So I see a recurring theme there, Shannon. So congratulations there.
Thank you.
And so very pleased to have Shannon here with us today. And I'm going to share my screen with Shannon and make her the presenter. and appreciate you taking some time out of your busy day to talk with us, Shannon.
Of course.
So you should see that
So Jeff, can
pop
you
up
see
on your side, and I do see your screen.
Okay.
Looks good.
Okay, perfect. Okay, well, hello everyone. Thank you so much for joining us here this morning. Jeff, thank you for that lovely introduction. Jeff, I think something went wrong. Can you see my screen still? Jeff, are you able to see my screen?
I'm able to see your screen, yes. Looks
Okay.
good.
All right, perfect. All right, sorry about that, everybody. Again, welcome, good morning. Thank you for joining us here this morning. And again, thank you, Jeff, for that lovely introduction. It looks like it's going to be a wonderful day outside today. And it's almost Friday, so I appreciate you joining me here this morning. We know there's a lot of other things you could be doing. So I'm so happy to be presenting on this topic to you today on the financial planning aspects of estate planning. But just a brief disclaimer, the following presentation is meant for educational purposes only. This is not to be construed as legal advice or a substitute for legal counseling. So there is no attorney-client relationship being developed here today, although I'm happy to develop one later in the future to help you with your estate plan. Okay.
Shannon,
Yeah.
maybe try to stay towards your microphone just a little bit more.
Okay.
You're kind of going in and out just a little bit.
Okay, I apologize about that.
That's
Is
okay.
this better, Jeff?
That is better, yes. Thank you.
Okay, I apologize, everybody, for all the inconveniences this morning. So let's start with what is financial planning. Okay, so financial planning is a comprehensive analysis of goals, your tolerance to risk, your life stage, taking into account your family, health, and personal circumstances. And then thinking about what are the suitable investments and general savings. And then taking into account, again, budgeting and tax planning, all to make sure you achieve your financial goals. So I am not a financial planner or a financial advisor. And, the financial planners and financial advisors who our firm regularly refers clients to would be able to go into much greater detail than this, but this is just a simplistic approach and a simplistic way of thinking of what estate planning is. So simply put, making sure that you have enough money to accomplish your lifetime and after-death goals. So then what is estate planning? Because today we're going to be talking about how financial planning and estate planning overlap and work together. So if you see this here, you'll see it's remarkable how similar this looks to the financial planning structure. It starts with, again, a comprehensive analysis of your goals, your tolerance to risk, your life stage, your family, health, and personal circumstances, plus taking into account what your financial and asset picture is, and then thinking through what the suitable legal documents are, all to achieve your estate planning goals. So I want to do a brief review of what estate planning is, because many people think that estate planning is only relevant at death. However, estate planning is more than that. It's also relevant during life in the event you're unable to manage your financial affairs, and this would particularly be in the event you're incapacitated. Estate planning is planning for the care of your health and property and assets while you are alive, particularly in the event you become incapacitated, and also planning for the disposition of your property at death and for the protection and care of those who are dependent upon you. So just to put it simply put, having the necessary legal documents to dictate who will handle things for you in the event you are unable to do so yourself due to, again, incapacity or death, and how they will do this for you. So how do financial planning and estate planning overlap? We talked about what an estate planning structure looks like. We talked about what a financial planning structure looks like. How do these two work together? How do they overlap? Well, a starting point is on both of the outlines that you saw for what estate planning and financial planning means is goals. What are your goals? And then the second question is, how will you finance those goals? So a financial advisor will be able to help you think through and plan to accomplish those goals. And then how will you ensure that your goals will be respected and accomplished in the event you are unable to do so yourself? And here is where estate planning documents and the legal structure of those documents come into play. An example of this is I've had clients who state to me that, they want to leave their house to their family upon their death. They want to make sure the house remains in the family, it doesn't get sold. Or maybe somebody has a cabin or a vacation home and they say, my goal is to make sure that this house remains in my family, it does not get sold. So thinking from the financial planning aspect of that is, how do you intend for the cost and the maintenance and other expenses that are associated with the property to be handled? How do you plan for your family members who will inherit this property from you to pay for the costs associated with keeping that property within the family? And then from the estate planning perspective, we want to be thinking through the legal documents and the structure of the legal documents that we need to have in place to ensure that that goal is accomplished. And in this type of scenario, perhaps having a trust plan may be the answer, and it typically is in this type of scenario. Another example is having your assets add to or supplement governmental benefits that may be available to your child or children with special needs. So sometimes I have potential clients come in and they say, my goal is to make sure that I can leave money to my child or my grandchild with special needs, but I don't want to disrupt their benefits. And, I want to figure out a way to leave enough money to them. So from the financial planning aspect of that, we want to think about how much is your child or grandchild likely to need, and how are you planning to have enough assets to fund that when you are gone? And then from an estate planning perspective, the important thing is, planning a structure. We absolutely do not want to leave assets outright to your special needs child or grandchild, again, because that really disrupts their benefits. And so there's different, estate planning tools that can be utilized. There's different estate planning structures that we can create so the money that you leave to that child does not disrupt their governmental benefits, but instead it supplements them. So those are just two examples. So I want to talk about asset alignment. What does that really mean, and what is it exactly that we're aligning assets with? So asset alignment simply means ensuring that the lifetime and after death access to and distribution of your assets are aligned with your intentions. So making sure that whatever your intentions are, whatever your goals are in terms of your assets, both while you are alive and after death, are in line with your estate plan. So let's talk about what a successful estate plan is. And you'll see here that I have listed out a two-step approach for a successful estate plan. So step one in having a successful estate plan is having the appropriate legal documents in place, okay? And the first legal documents that are important and should be in place are what I call your incapacity planning documents. So that's the financial power of attorney and the advanced medical directive. Our firm utilizes two financial power of attorney documents, the Maryland Statutory Financial Power of Attorney document and the General Durable Power of Attorney document. Those documents allow you to name somebody, dictate who will manage your affairs, your assets, your properties in the event you become incapacitated. Okay, so who is going to continue paying your bills? Who is going to continue, paying your mortgage if you have one? Who is going to continue and keep up with your property and pay your taxes? Who is going to keep things going when you're unable to do so yourself? And then the advanced medical directive, naming an agent to make healthcare decisions on your behalf. Again, in the event you are unable to do so yourself, particularly in the event you are incapacitated. And that document goes into 3 different sections. It talks about, again, naming agents. The second part of that document talks about your end of life preferences. And the last part of that document talks about post-death instructions. It talks about funeral and burial, cremation and memorial service, those types of things. And you can really customize that document to make sure that it meets your intentions and your wishes. So these documents, they're very important. And some may even argue that they are more important than your will or trust. But I believe that they are equally important because what they do is they avoid something called guardianship. They avoid the court becoming involved to name a guardian of your person or property if you're unable to manage your financial affairs or unable to make healthcare decisions on your behalf. Now, guardianship, it does really strip you of your rights. And so by planning ahead of time and by having a power of attorney document, a financial power of attorney document, and an advanced medical directive, you are ensuring that the court doesn't become involved because you've already named people to make these decisions for you if you are incapacitated. And it's a least restrictive mean to guardianship. You can lay out exactly what your wishes are in these documents. And then making sure you have the appropriate legal documents at death, whether that be a trust or a will, and which of those legal documents will accomplish your estate planning goals and intentions. You know, if I have a client come in and they say, I want to avoid probate, they have an aversion to probate, they're motivated to avoid probate, then talking through a revocable living trust plan is probably the best approach. Or maybe a client comes in and they say, I have a child with special needs. I want to make sure that I don't disrupt their governmental benefits. I want to make sure that I can leave money to them upon my death. So in that instance, that is their goal and that is their intentions. And perhaps in that instance, the best approach would be a trust. And then step 2 is making sure your assets are aligned with the plan. So making sure that ownership or titling on your assets and your beneficiary designations are in alignment with your estate plan and your legal documents. So something that I commonly hear from people is, I have a will, I have a trust, I've signed those documents. Isn't everything just covered at this point then? And that's not true, okay? The asset alignment portion is very important, especially in the instance of a trust. Simply signing a trust doesn't avoid probate. So actually aligning your assets to the trust is what avoids probate. So here is another example of why asset alignment is so important, and another example of why there is a significant overlap between estate planning and financial planning, and why it is so vital that the estate planning attorney and financial advisor work together. Jeff, I'm going to pause here. I just want to make sure we don't have any questions.
Thanks, Shannon. No questions as of yet. Appreciate you checking in. I'll let you know if we do.
Okay, perfect. Thank you. So next I want to talk about the nuances of beneficiary and payable upon death and transferable upon death designations. The when, why, and how of these. So I want to start by saying that I do not recommend that all of your assets be beneficiary designated or payable upon death or transferable upon death designated. I especially don't recommend that this type of designation be in place of an estate plan. But it really depends on the type of asset. So sometimes we want to utilize beneficiary designations. An example of this is retirement plans. It is vital that the beneficiary designation be complete and kept up to date, because those types of accounts are very nuanced from a tax planning perspective. So we have to be very careful in terms of making sure the beneficiary designations are done correctly. Another example is checking accounts. So we advise clients to make checking accounts payable upon death. And typically, this is because the client is utilizing some type of trust as their estate plan. And we really don't want to cause a headache for clients during their lifetime when it comes to checking accounts. So typically, clients just have their income set up to come into the checking account, and then automatically their debts will be automatically removed from that account. So typically that means that their checking account doesn't really get up to a high level of assets, and it's the assets are in and out of that account on a monthly basis, income coming in, debts being paid out. So we typically recommend, if somebody is utilizing trust planning, to make their checking account payable upon death to the trust. Okay, so I want to talk about non-probate transfer devices, because again, sometimes people believe that simply utilizing these non-probate transfer devices in place of an estate plan will simplify things. So having a joint owner, having a beneficiary designation, a life estate deed, transferable upon death designation, payable upon death designation in trust for accounts, that these things will avoid probate, and that they don't need to actually have an estate plan in place. But in fact, by taking this approach, you are skipping a step, and that can actually backfire. So some examples of how this can backfire. Example number 1, I have had people say to me, well, I made my daughter or my son a joint owner on all of my assets. And by doing that, I've really made things simple. She can access my money to help pay my bills. And when I die, there will be no need for probate. The assets will go directly to her. It's as simple as that. Well, unfortunately, it's not as simple as that. There are risks of doing that. The risk of doing that is that your daughter, she's now an owner on that account, so it opens up her creditors to that account. So by adding your daughter's name to your account, that is also adding your daughter's creditors. Or some people say to me, all of my assets are listed as payable upon death, transferable upon death, they're beneficiary designated. And now I don't need an estate plan. Exactly what I was talking about before and how we don't recommend that approach. But what if at your death, someone you have made an account payable upon death to has predeceased you? And now that asset will have to go through probate. And if you did not have an estate plan in place, then your estate plan may not go to where you intend for it to go to. It may not go to the people you want to receive it. It will have to go by state law. Another example of a risk is naming somebody as payable upon death on your account. What happens if that person is going through some sort of creditor situation and then or a divorce? And then upon your passing, that money funnels directly to them. So now that money instantly goes to them, and then it instantly after that goes to their creditors. So you really want to make sure that you have a robust estate plan that takes into account different contingencies, if certain things occur, and what you would want to happen. And an estate planning attorney can walk you through what those different contingencies might be and the provisions that should be in your document to make sure that everything flows correctly in the event of your passing. So just showing how these non-probate devices will transfer if they do not flow through a will or trust and meet those different contingencies. Joint ownership would pass to a surviving joint owner. Payable upon death or transferable upon death will pass to a beneficiary, as well as beneficiary designated assets, which the common ones there are retirement plans, annuities, and life insurance. Those pass to a beneficiary. In transfer accounts pass to a beneficiary, and life estate deeds would pass to a remainderman. So what does the statement, don't leave your 401k or your IRA to your minor child or grandchild really mean? So the complication of a minor inheriting assets is that someone under the age of 18 cannot legally own property. So say, if a 16-year-old inherits property, it will require that a court guardianship matter be open where the court appoints a guardian to be responsible for the inherited assets on behalf of the minor who's inheriting the assets for you until they turn 18. So there's multiple negatives to that. One is, of course, we want to make sure that the court is not involved. We want to avoid the court's involvement as much as possible. And number two is, even at 18, most people would agree that we don't want an 18-year-old to be in charge of a large sum of money. So it will require the court's involvement unless the appropriate planning is done ahead of time. So I've had clients say to me, this is just a brief example, that, I will just leave my assets to somebody else instead. And, they know that I want that money to be used to take care of my grandchild or my child. They know what I want that money to be utilized for. And whether you believe that that person will use the assets in a general way that you've spoken to them about, we just have no guarantee. We unfortunately cannot foresee the future. And once that asset is theirs and put in their name upon your death, it is subject to their creditors. Or, what if the person that you leave the money to provide for your grandchildren or your child loses their mental capacity? So now someone else will be managing their assets for them instead of that person who you feel knows that you want the assets to be used to provide for your children. So if somebody loses their mental capacity, someone else would be managing their assets. And that person may decide that they want to use those assets for the incapacitated person's benefit. So the person they have power of attorney over. They want to use it for their needs instead of for your children's needs because it's in their name. So what is the solution to this? The solution to this is to make sure that you have built in your estate plan for your minor child or grandchild a trust. So you will be leaving assets in trust for their benefit, and then you get to dictate who the trustee is, which means the person who will manage those assets in trust for your minor child. You can also state that maybe, at 25, your minor child can act as a co-trustee with the trustee you have named, and they can learn the ropes and manage that money with them. And then maybe at 13, and maybe at 30, they can manage the assets on their own. And also doing this type of trust planning allows you to state specifically when you want assets to be distributed out to your child and for what purpose. So it really allows you to customize it. So that is typically the solution that we offer to clients who have minor children. Okay, so let's talk about the financial advisor from an estate planning attorney's perspective. So many people tell me that, they don't need a financial advisor and that they can manage their assets on their own. They can manage their investments on their own. They've been doing it fine, and that they don't feel that they need to pay someone for something they can do themselves. So from an estate planning attorney's perspective, there are many benefits that come from working with a financial advisor above and beyond simply making you more money. So the benefits that I personally observe are as follows. What happens if you become incapacitated? The benefit of having a relationship with a financial advisor is that there will be a seamless transition. In the event you become incapacitated and you're no longer able to invest for yourself or make those decisions, you don't need to worry because you have a professional who has been involved and part of your financial picture who will be able to continue that in the event that you are not able to do so yourself. And on a similar note, after your death, of course, after your death, you won't be able to manage your investments and your assets. So having a financial advisor who had a relationship with you will able to seamlessly help navigate the transition from your lifetime to what happens after death. And that provides great comfort to family and beneficiaries because they know that you have everything planned and in one place. So getting to my next point, when you develop that type of personal relationship with a financial advisor, it helps your family or who would be stepping into place as your fiduciary next. It helps them know what you have, how you have it invested, because they might not know otherwise. So they'll be able to have somebody who they can reach out to and contact and see how all of your assets are listed and know that your assets are all listed in one place. So they don't need to go looking for them after your death. A financial advisor also provides an objective oversight. So many times I have clients who say to me, you know, I'm very worried about naming somebody as my power of attorney. That allows them to have access to, these really important things, my money, and I want to make sure, that, somehow they're being supervised. Is there anybody who looks out for this? And I say to them, unfortunately, there is no supervisor to make sure that your power of attorney is behaving properly. There is no state of Maryland person who watches out for this. They are obligated to behave properly under the law, but there is not somebody who is actually the supervisor. So I say to them, it maybe having a financial advisor would be best to help your worries. So one of the benefits of having a financial advisor involved in your financial world is that you have someone who is paying attention, who will notice if huge withdrawals are being made from your account, or if inappropriate behavior is taking place, and they can red flag that. So what is the ideal advisory team? So here are the core three. You want to have an estate planning attorney, a financial advisor, and a tax advisor. The financial advisor and the tax advisor, they really overlap, but just in general, all three of these overlap. And these are areas where professional guidance and professional relations will help you achieve your goals and any concerns that you may have. Jeff, do we have any questions before I go to my next slide?
Thanks, Shannon. We actually do have one question, and it references a vehicle. How would you, the question is, how would I leave my vehicle, basically? So it's kind of an open-ended question. Do you have any general thoughts about how to leave a vehicle or how it should be possibly titled once somebody passes?
Right. So we recommend that, when you do estate planning with us, we recommend that you leave your vehicle as a transferable upon death designation. And you can do that through, I believe, the MBA website. I think you used to have to be able to go in and do that. But, by working with us, we can provide you information on how exactly to do that.
Okay, thanks, Shannon. So you jumped out there just a bit. So that was a transferable and death designation that you said.
I recommend that they do a transferable upon death designation. So I recommend that they go on the MBA website and they can list somebody to transfer the car to upon their death.
Okay.
It doesn't have to go through probate. And,
Okay.
through working with us, we can provide information on how exactly to do that.
Okay, great. Thank you.
Anything else?
Not right now. Thank you.
Okay. So I'm actually here at the end of the presentation. So, what do we suggest you do now? What is a path forward? So we recommend that you set a consultation with Elville and Associates with an estate planning attorney. Bring in your current estate planning documents for a complete review. And we can let you know if, we believe that the documents should be updated, or maybe a better plan should be put in place based on your current life circumstances and what your goals and intentions are currently in your life. We highly recommend that you come in and meet with an estate planning attorney if you don't have an estate plan in place, so that we can meet with you to discuss your goals, your intentions, and speak with you about how best to achieve those goals and intentions through estate planning. And then we want you to consider whether you have an advisory team that I showed you on the last slide, which includes your financial advisor and your CPA. And if you don't have these people in place, we can recommend people to you who we frequently work with. We recommend that you prepare any questions or concerns you may have ahead of time. Really take time to think and decide what is important to you and what your goals are, so that you can present them to us and we can recommend a plan that best meets those goals and intentions. Our consultations are complimentary. They're an hour-free complimentary consultation. I know that sometimes it is uncomfortable to talk about these types of things, but I just want you to know that there's nothing to fear. There is only information to be gained. There's only knowledge to be gained from this. So thank you so much for joining us today on the webinar. If you have any further questions, or if you want to meet with an estate planning attorney or myself, you can contact our firm. My contact information is listed there, or you can contact Jeff. His information is also listed there. And Jeff, are there any other questions? I just want to make sure we get to all of them.
Thank you, Shannon. So now would be a great time to pose any more questions that you might have for Shannon, and appreciate you being with us today, Shannon. Thanks for all the great information. And I'll just echo what Shannon said there at the end. Even me working at the firm for 10 and a half years at this point, it took me a long time to update my estate planning pretty recently, but I felt so much better once I did it. And there was nothing to be concerned about. It was in a relaxed setting, and certainly I knew the people I was working with, but just sharing the information and getting it done and knowing it was accomplished made me feel so much better. That's something I would just encourage everybody to do. I didn't even realize after several years how many things had changed in my life. So something to certainly consider if you haven't looked at it in many years, or if you don't have one yet, which most people don't, which may be surprising to you. So I'll be sending out today's video link along with some other links from some previous presentations that kind of go hand in hand with today's presentation. And I'm really excited about what we have upcoming in our webinar series. We have some really good presentations coming up, some new ones as well, with some guest presenters that we have some good relationships with here at the firm. But tomorrow, Steve's going to be back talking about what elder law attorneys are advising clients in 2024. And then on May 15th, we get back to the essentials of estate planning and elder law with Steve. And then we switch things up a bit. On May 16th, we're going to welcome Marie Ritzenberg, who's a mortgage loan officer with Main Street Home Loans. She visited our office and talked to our attorneys and staff about the family opportunity mortgage. And it was such great information, we said we need to make this a presentation. And so the family opportunity mortgage, empowering families seeking to provide housing for loved ones. That's something that you do not want to miss. So that's on May 16th. I'll be sending some information out about that. And lastly, we're going to welcome Max Reamer of the Quantum Group. He is an advisor with them. He spoke at our client event last November and was terrific. He advises a lot of our clients and is really great, talking about life and long-term care insurance in today's markets. And that's been one of our most highly requested presentations for a while. We have Max coming in. He's going to do a great job for us and you. So a lot of things to look forward to in our webinar series. And we hope to see you soon again. And we appreciate you being here today. And we'll see you again soon. Have a great day and a good weekend. Thanks very much.
Goodbye, everyone.